you have an internet show called The Creature Feature?
Creature Features, yes.
Right, and do you do anything to them to make them yours, or you just air them on your channel? What is it you do?
This is the plaintiff, Louis Justin. He says the defendant is a bootlegger, and the guy stole a film of his and uploaded it on the internet without his permission. That's a big no-no. He's suing for $10,000 for his damages. This is the defendant, James Curry. He says he's the host of a late-night internet show about old horror movies. The plaintiff claims he has the rights to one of the ones he commented on, hasn't shown him proof, and he owes him nothing. He's accused of scaring a guy silly.
All parties, please raise your right hand.
What you are about to witness is real. The participants are not actors. They are actual litigants with a case pending in civil court. Both parties have agreed to drop their claims and have their cases settled here before Judge Marilyn Milian in our forum, the People's Court.
People's Court is now in session. The Honorable Judge Marilyn Milian is now presiding. Litigants have been sworn, Your Honor.
Thank you, Douglas.
You're welcome.
Okay. Mr. Justin, you own a company called Massacre Video?
Yes, ma'am.
Tell me what you do for a living.
We release old horror films. We do restorations off the original negatives. We do new stuff too, mostly low-budget films. So we work with the producers, buy the rights to them legally,
And what do you do with them?
we sell them. We produce DVDs. We license them to streaming companies. So we just, once we own the rights, we just exploit them for our company's gain to keep going.
Okay. How long have you been doing that?
I started when I was 17 years old.
Oh, how long have you been doing that? I don't know how old you are.
Wow. Yeah, I'm 30 years old, so I've been a while.
Okay, so you've been doing it quite a bit of time. All right. Did you know the defendant before what we're about to talk about happened?
I did not know.
Okay, so what happened?
I was doing my normal search of the internet for bootlegs of our films, and I came across Mr. Curry's channel where he was bootlegging our film Hack-O-Lantern and using a ripped master from our Blu-ray. And that's how we discovered that he was bootlegging the film.
So what do?
From this point, I then use my tools that I have with me, which is I am able to contact YouTube and Vimeo and have the video removed via the DCMA Act.
Okay, and you also filed a complaint against him with DCMA. And what is DCMA?
That's the Digital Millennium Copyright Act. It works with sites like YouTube and Vimeo that as like a middle party when there is rights disputes.
Okay, Mr. Curry, talk to me and tell me what is it you do?
Well, as you said, I have an internet show, and I show old movies and so forth. And I found this movie and ran it. And the first I heard of a problem is when he filed a DMCA notice.
Right, but you know you didn't produce that movie. Whose movie did you think, I mean, why is that okay for you to air other people's movies? Like, why would you think that that's all right?
Well, there's no extent, well, I shouldn't say that. The filed copyright has sort of expired. The producer's dead, the director's dead, the company went under, they sold the rights years ago. So there's no active copyright protecting it. I didn't know that at the time. I, like many other horror hosts, work through a series of lists that we share, or some of us share, and this was on it. I often preload a movie onto a different account on YouTube for weeks, months, sometimes even years before I get a chance to run it, giving me the chance to have people file complaints should it be copyrighted or currently being used.
Right, but okay, but what efforts do you make before you put someone else's intellectual property on the air? Because I think you know that you can't do that that's not permitted. So what is your theory, that the movie is so old it's no longer copyrighted? How old is the movie? It's from the 80s, right?
Yeah.
Yes, it was produced in
so
1980.
it's not that old that is, right? And post 1978, you don't have to go and file a piece of paper anywhere. Post 1978, everything is assumed to be copyrighted when it's not your intellectual property, right? It's not your creation. So you said, like other horror hosts, that's what you have an internet show called The Creature Feature?
Creature Features, yes.
Right. And do you do anything to them to make them yours, or you just air them on your channel? What is it you do?
Oh, actually, I do quite a bit. And specifically this one, I found a very poor quality 360 resolution original, which I remastered myself, adjusting color, sound, framing, and of course, the resolution, and upscaled it to 4K.
Okay, but...
So I invested a great deal of time and energy on it.
Right, but Mr. Curry, it's someone else's property. You know it's not your property, right?
True. But
right, so every movie that you put on, if you don't have permission, yeah, but time is like 1920s. Time isn't from the 80s. I mean, you know, when you say, oh, when time, it becomes public domain, we're talking about really, 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 really old flicks, not something from, 30 years ago.
Correct.
Right, so you know that what you're just banking, it's just a cost of doing business for you. You're banking on not getting caught, but which, okay. But then when the guy calls you and says, or emails you and says, stop this, how is it that you're jabbering back at him like, prove to me you own it?
As I point out, I have regularly had people contact me and say, oh, I own the rights to that. And I ask, okay, cite your source. None of them have ever done that, because almost all of these people are people that, they don't own the rights, or they have no contract, they have nothing. They're just people.
Why would they care? If the people didn't own the rights, why would they call you and tell you to stop airing it? They don't care. Like, if they didn't own the rights,
people
they wouldn't
bored.
even call you. I mean, people get bored.
There are internet trolls and so
okay.
forth. So.
Yeah. All right. So talk to me about Massacre Video and how it owns the rights to, what's the name of it? Hack-a-Lantern?
Hack-a-Lantern.
What's Hack-a-Lantern about? Tell me what
Hack-a-Lantern is a doozy. It is a film that is Indian produced. It was made for the American markets, and it was meant to kind of go off Halloween and the successes of that. So they made their own basically low-budget film, and it was the producer who is very much alive, Rajesh Mathrota's first feature, and he produced it here. So it's just a story of a satanic family based around Halloween. It's a very just goofy B horror film.
Okay, and when you say he's very much alive, is he available there to testify? I believe you said he was there as a witness for you?
Yes, he is here to testify.
May I speak to him to see how alive he is?
Absolutely.
Hello.
Hello, sir. How are you?
I'm fine. Yeah, I'm the producer of the film and owner of the film, and I sold it to Massacre Video, and this guy claims that he owns the copyright or whatever. I don't know.
Oh,
But
he
I'm
doesn't
the
even
producer
claim
and owner
that.
of the
It's worse than that. He just says, you prove you own it, or I'm not going to stop violating copyright law. So when you say you're the producer and owner, did you or didn't you sell the rights to the plaintiff, to Mr.
Yes,
Justin?
I did.
Okay, and how long ago did you sell them?
2-3 years ago.
And is it forever or just for a limited period of time?
It's forever, provided I get my
Okay.
payments.
Provided you get your payments. Well, I'm sure he'd like to get paid, but it's hard for him to get paid if someone's putting it on for free. You sell this on Amazon for how much, Mr. Justin?
It goes through our distributor, so we're getting a wholesale price from our distributor, but I believe the retail on Amazon is $29.99 for a physical copy, and it is actually being streamed legitimately on Amazon Prime as well if you have a Shudder account, which is a subsidiary of AMC. So we have studios licensing it from us.
Okay. And did you ever talk to Mr. Curry?
I did not personally talk to him. I had a colleague of mine call him before we filed the suit just to attempt to solidify it over and just let him know we do own it. And unfortunately, per Vimeo's rules, once he filed a counterclaim against us, we were forced to take him to court to get the video shut down. They would not be the middleman. So I called him just so we wouldn't have to go there. And he was very just showed his blatant misunderstanding of copyright law and was very arrogant to us. And
what did he say?
then demanding we
What
own
did he say to
paperwork.
you?
Well, in our first email with them, I told him that we did indeed own the rights to this, and Mr. Curry stated, "You may own the rights, but there is no copyright for it, so you can't stop anyone from using it," showing, even if I showed him the paperwork, he is not going to stop.
All right. Did you do any research online or anything to see if they were registered, if the film was registered, Mr. Curry?
At that time, before that, no, I hadn't. As I said, I was working.
When
off
did
of
you
a
do
list.
that? Right.
Well,
when
after
did
the
you do
gentleman
that?
called.
And then what? What'd you find?
Well, I found that there is a copyright, as I said, for a company that doesn't exist anymore. And my lawyer, as we pointed out, said, I'm not wearing the white hat here. I'm not wearing the black hat. It's a gray hat because an error was made. Now,
Oh, I don't
if
think
they
you're
had sent me
wearing a
the
gray hat at all. When you say error, an error was made by who?
well, by me in this one, yes.
Oh, okay. I understand what you're saying. Here's a rights assignment. And of course, we had direct testimony from the producer.
Yes.
But your channel, Mr. Curry, how were you even able to get the name The Creature Feature Show? Or I guess there's a lot of I remember watching something called The Creature Feature Show.
Yes. I mean, I was actually back in 2008. Oh, I should say back in the 70s in San Francisco, there was a creature feature show with Bob Wilkins, and the director was Tom Warsh, and he knew an associate of mine. And in 2008, they came out with a retrospective about the original host, Bob Wilkins, and he asked the associate of mine and I to bring the show back to raise interest in his movies. So we did that, and I've been doing this ever since.
And I saw that there was some litigation over the name The Creature Feature. Tell me about that.
I had the name. I've been using the name Creature Features in good faith, and then a couple of years ago,
You went out and you trademarked the name because they hadn't thought about trademarking it, or there was no,
Well, as I
or it had
understand it-
expired from the original show, or what?
as
So
I
you kind of
understand
get
it,
the
Mr.
idea
Warsh-
about rights and violating rights and having rights. I think you get it, right?
Oh, I get it and all, but I would take
Yeah.
umbrage with the argument that I was somehow aggressive or a problem here. I was actually quite polite to the gentleman, and as I point out, lots of people say things. It doesn't mean anything. As my lawyer once said, you can say anything you want until you get in front of the judge. Then it's got to be the truth. So shows like mine are always starving for content. So we're always happy to talk.
Yeah,
to
because you don't
people,
own any.
and-
Right, but that's the problem. You're starving for content because you don't own any. Now, Mr. Justin, what is it you're asking for here today?
I was asking for $10,000 in damages. It has damaged the thing and just the time we've had to spend on this case because it should have went away after the very first complaint. It's the fact we had to take it to court was I think, fourth step already. Like there were 3 steps that got us here already. So
You need an order, though, that says that a court of law heard it and found in your favor in order to keep it off of those other sites.
Yes, ma'am.
Correct?
yes, ma'am.
All right.
This was something we were not wanting to do at all. We tried to not have.
Yeah,
make
it shouldn't
come
have
to
gotten this
but
far. It shouldn't
yeah,
have gotten this
I
far.
very
I am
much
finding
agree.
in your favor, not in the amount of 10,000, because you can't really show me damages in 10,000, can you? It's not like you can show me a decrease in sales or whatever. But I'm Mr. Curry. I don't agree that this is gray. I think this is extremely black and white. I think that this ended up causing him a great deal of heartache. And if you have a lawyer who you consult with, perhaps you should consult with him on what the definition of public domain is, because this is not it. Okay? And perhaps you already have, and you know that only full and well. I am ordering a verdict in favor of the plaintiff in the amount of $2,500. That's my judgment.
Thank you, Judge.
So the plaintiff gets $2,500, not $10,000. Mr. Curry, the defendant, you know, you got caught this time, and it's costing you. What are you thinking right now?
Well, as I said, I was working from a list, and an error was made, and this happens from time to time, and you take it in stride, and you move forward, and you try to do a better job. It's not like there's a guide on how to go around doing this.
Well, hopefully in the future you'll be more careful. Really, no kidding. All right, Mr. Justin, you were seeking $10,000. You didn't quite get that, but you are victorious. So how do you feel now?
I feel great. Mr. Curry was aware of what he was doing. After we served him the documents, his YouTube channel went from 70 videos down to 4. He knows what he's doing. So I'm very happy with the judge's decision.
All righty. Well, good for you. Congratulations. All right.
Thank you,
Let's
sir.
join the judges now for another session of After the Verdict.
Certainly in this case, plaintiff was entitled to be compensated.
Aren't you dying to see this horror flick now?
I just don't remember a lot of Oscar buzz back in 1988 on Hackle.
Yeah, but there's nothing. There's nothing better than B horror movies. I love it.
No, I love them too. Are
Yeah.
you kidding me? I'm a sucker for a good scary movie. Love them. Yeah. But yeah, Hack-O-Lantern was not one that I ended up seeing.
I think the defendant knows full well and good what it is that he was doing,
It seemed
and
that
it's
way.
not gray in the slightest. And he was kind of arrogant in the correspondence.
And if you're in the shoes of a guy like this plaintiff, you have to be eternally vigilant and constantly looking around and checking to see who's using your stuff.
Right. That's got to be no way to live. I hope he makes a good living doing this. It's a kind of a really cool job. I mean,
I guess. What he needs to do is register his copyright.
he does. It's just a form. It's not that difficult. Right. And then he can go into federal court and slam people.
And get attorney's fees.
And get attorney's fees.
Greater money damages, etc.
Yeah.
So Terry wants to know this. Hey, Harvey, my gym refuses to refund payments when they were closed for COVID, and my credit card company is siding with them. Can I sue in small claims court? Look, this is an open question. The appellate courts have not decided this yet, and it's going to be decided on a state-by-state basis. I think it's close, and my gut is that the gym would probably win the lawsuit, but I'm not confident the gym would. I think it is an open question. You could try it. Going to small claims is not that hard to do, but I wouldn't spend the money before the judge rules. That'll do it for this case. Litigants for the next case inside the courtroom.
This is the plaintiff, Wayne. He says he ordered tiles from the defendant to redo his bathroom, and the guy screwed up the order big time. He wants a refund. The defendant's not an honorable businessman, and he's suing for the $1,274.83 he's owed. This is the defendant, Joshua Sherrill. He says the plaintiff ordered tiles in 2 batches, and when you do that, you run the risk of tiles being off in color due to dye batches. He's sorry, but the plaintiff refused to work with him to eradicate the problem, and he owes nothing. He's accused of being a little off color.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case on the docket. The plaintiff says the store where he purchased bathroom tiles is ripping him off because the tiles were the wrong color and he's not getting a refund. But the defendant says the guy bought the tiles on 2 different days, weeks apart, and they don't guarantee the dye batches for the 2 separate purchases. It's the case of being a little off color.
Thank you, Douglas.
You're welcome.
Okay, Mr. Wayne, you were embarking on a home improvement project. You were remodeling your bathroom?
That is correct, Your Honor. I was retiling the old shower.
Okay, so you went to the, you're the manager at the store, Mr. Sherrill?
Yes, I am the manager.
So you went to the store and what did you purchase?
I purchased 7, 8 cartons of wall tile. And then I also ordered what they call bullnose tile, which is a finished tile.
Okay. Now, what makes it a bullnose tile, Mr. Sherrill? It's a narrow kind of strip that's on the trim. Is that correct?
Yes, that is correct. It has a rounded edge. So it basically gives
Rounded
a nice,
edge on the top,
clean,
yeah.
finished edge. Yes.
Little finish. All right, so you ordered it, and then it came in, and you picked it up when?
I picked it up approximately the first week of January of 2020.
Okay, and so we're talking about how many boxes of tiles?
It was 8 cartons of wall tile and 1 carton of bullnose tile, which included 36, and then 8 loose bullnose tiles of the chocolate color, and 4 bullnose colors of what they call the ecru color, which is like an off-white cream.
Did you inspect them before you left the store?
Well, I picked them up at the warehouse. When I did pick them up at the warehouse, I looked at them, opened the carton of the 36, pulled out 1 tile. It appeared to be the same as the others.
You didn't look at all of them?
No, no, Your Honor, I did not.
Okay, so then you go home, and what happens?
Well, I started the tiling job about the first week of February, and then by the end of March, the bullnose tile is actually a finished tile. So you finish off the edges, and they usually go up last.
Right.
So by the end of February, beginning of March, I installed first the 8 pieces of loose tiles, which were the same color as the wall tile. When I went into the box, it was a hodgepodge of different colored tiles. Same color, just a little bit lighter. It's a different tone, if you will.
Okay, so what'd you do?
And well, I went back to the defendant's place of business, and I informed him of that. And the sales associate I was working with was going to contact the tile manufacturer, who was in Italy. This was about the beginning of the COVID-19 start. So Italy was one of the first countries to lock down. So it took quite some time for them to get back. When they did get back, we were informed that that tile that I purchased had been discontinued.
So they couldn't obtain any more bullnose?
That is correct. The tile line
So
was
then what'd you do?
discontinued. Well, the sales associate I was working with had reached out to the tile representative of the distributor here, and we decided what we would do because there was no more bullnose available, that the tile rep would go to his retailers in his district and get as many of the wall tiles as he could, and we could make not a true bullnose, but we could get 4 tiles to cut down that would maybe mimic a bullnose.
Okay, and then, so did that happen?
It did happen. The sales rep did get 16 tiles. Of the 16 tiles, only 4 of them were the correct color. The other 12 were of the lighter brown, so they couldn't be used.
So then what'd you do?
Well, then I called the defendant's place of business again. They had one of their installers come out to take a look at it, and he said, you know, he could probably do it, but it's could be at this point just trying to salvage the job of what I did, and he wouldn't have been pleased with the way it looked.
Why wouldn't he be happy with the result?
He said, what he said to me is he don't think that would look very well because the rest of the shower was done properly and nice. And now what he was doing, he's just trying to throw something
Well, no,
together.
you'd have to rip out those tiles, and then you would have to have enough of the correct color and then do a complete bullnose around that where it all matched. But nobody's finding the tiles because you need more tiles. Why? Because according to you, the box that you bought had different color browns in it, that there's variations and shades. Let me hear from you, Mr. Sherrill. What do you know about this case?
Okay, so a lot of the things that he has said, he's left out a lot of truths. So when it comes to tile is made with a production run. And with each production run, whether they produce 10,000 or 100,000 square feet of those tiles, every one of those would be the exact same color. When it comes to bullnose actually is not dye lot specific. So there is never a guarantee that any bullnose will ever match a specific lot of a tile that is produced.
So if I go to your store and I've ordered bullnose and tile, I've actually done this. I've actually stood at the warehouse opening like 3 or 4 tiles from each box. They were so mad at me. It's not normal that people do that, but if I'm buying tile at your store and I don't do that, what's your policy?
Our policy with a cash and carry, so it's different because the main portion of our business is actually to do the installation itself. So if this was something that we ran into when we were to do the installation, it would have been addressed immediately. But Mr. Adams purchased the tile and the bullnose, and once he took possession of it, it states clearly on the invoice and the disclosure that he signed stating that there is no guarantee in dye lots and that all sales are final on a cash carry. There are no returns on special orders, which his order was technically a special order. And a customer takes possession of it. See, when it comes in, we inspect it. We make sure that there's no damage. Once the customer takes possession of it, technically they own it. It is unfortunate that the bullnose didn't exactly match his tile, but that's totally out of my control. And that's why we actually attempted to see if we could acquire additional bullnose that we were going to give him free of charge.
Can I ask you, he says that your guy that you sent over there said, oh, this isn't going to work. Is that true or not true?
No, he took his own tile and he had his own installer. We wanted nothing to do with his installation because he was refusing to pull a permit. I actually went to the county's website and pulled up his address, and there are no permits pulled for his shower, which is a code violation. When he came in, the plaintiff did, and he told the owner that he thinks that he should do something about the situation. And the owner asked him, well, I need you to elaborate. And the plaintiff, he then stated that we should provide him with free tile and free installation, which then the owner proceeded to tell him, absolutely not. We will not give you free tile and we will not do your installation. And so the plaintiff then threatened the owner by telling him, I hope you have a good attorney, which I heard those words come from the plaintiff's mouth. And therefore the owner told him straight to his face, I'll see you in court. He said, I'm sick of people coming in here trying to take advantage of good business owners.
Mr. Wayne, let me ask you a question. Do you read the contracts that you sign?
I did read the contract, what they call the contract of purchase.
And what does it say?
Well, it says, I believe, on the third paragraph, materials will be inspected and damaged product will be returned to manufacturer. Then the next paragraph, it states, is not responsible for die lot differences when attempting to match
go a
existing
little higher.
materials. Yeah.
In between those two, the flooring company is not responsible for any damaged products once a customer takes possession of materials. You see where
Correct,
that is?
it does say that. I do see that.
Yeah, so if it says that, let me ask you a question. Isn't that then an absolute defense to you complaining 2 months later that you don't like what you picked up in a cash and carry situation?
Well, no, Your Honor, I believe that the tiles weren't damaged, they were miscolored. Now, if I go down to the next paragraph, where it says is not responsible for die lot differences when attempting to match existing materials, my existing material did not match.
No. Cash and carry is cash and carry. Cash and carry is like there's no returns and you go to the store and you ordered it and it came from Italy and then you take it and you better inspect it before you take it. And that didn't really happen. You yourself say they looked to match. I don't think you looked. And then 2 months later, it's a problem, but you want them to eat the entire problem instead of you eating the problem. And that's the problem that I'm having because it's your project. And if some of them don't match with the other ones, that is a typical thing. You're claiming that it's the 36 tiles that don't look the same. He's claiming he bought more bullnose and they're different, you know, whatever. He's also telling me, but it's entirely possible, Judge, because bullnose isn't from die lot. I don't know. I do know this, though. I don't know tile, but I know contracts. And your contract means that you're out of gas here. And my verdict in this case is for the defendant.
Wayne, let me ask you, what's your reaction to the judge's verdict? What are you thinking right now?
Well, I didn't exactly, I respect it. I don't agree with it. I just wanted the tile replaced.
All righty. Well, I'm sorry for you, but that's the judge's decision. You're going to have to live with it. Sorry about that.
Yeah.
Mr.
Yes,
Sherrill, let me ask you, how do you feel about this case? I would imagine you feel pretty good right now.
Yes, sir. I completely agree with the judge's decision. And, you know, I'm not a spiteful person. And, you know, I did try to help the plaintiff out as much as I possibly could. And unfortunately, it didn't work out for him.
Well, congratulations. You win the case.
Yes, sir. Thank you.
All right, let's join the judges now. Here's another edition of After the Verdict.
You say you don't know tile, but you do know contracts. I'm here to tell you, she knows tile, okay? Because you've been bit by this dog before. The same things happen to you. We went to half a dozen tile places at least, and we're in the back in the warehouse, and you're opening up boxes, and the people working there are getting aggravated at you, and it was...
Sure. I would never cash and carry out of a tile company without pulling out several tiles from every box.
And at the end of the day, it's a contract case, and it says cash and carry. So, I mean, you get the cash and carry stuff for a better price probably, but you're stuck with the consequences if you don't open it up and check everything out. It's like going to the drive-through window for the burgers. If you don't look in the bag before you leave, you might have a problem.
Something you're an expert at.
Never look, never.
So Michelle wants to know this. Hey, Harvey, I rented an apartment with my boyfriend and he left me and is now ghosting me. Can I remove his name from the lease and then move out? Well, I'm not sure why you want to remove him from the lease, because as long as he's on that lease, he is responsible, along with you, for any breach of the lease, like back rent or damage. So honestly, don't remove him. If you remove him, if the landlord allows that, he's off the hook. And you don't want that. That'll do it for this case. Litigants for the next case inside the courtroom.
This is the plaintiff, Falua Tupou. She says she agreed to rent 2 rooms in the defendant's house and gave him a deposit. A week later, she found a better deal, and when she asked for her money back, the defendant said he already spent it to fix up the house. He's not allowed to spend that money. It should have gone into escrow. And she's here suing him for the return of her hard-earned $2,500, the amount she gave the defendant. This is the defendant, Marcelo Moat. He says he had his previous tenants move out once he got a security deposit from the plaintiff. Then she tells him she's having some financial issues and she wants her money back. Well, this woman has now caused him to have financial issues because the rooms sat vacant for 2 months due to this woman, and he's not returning a penny to her. He's accused of holding on tight.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case on the docket, the plaintiff says that she gave the defendant a deposit for an apartment, and now the defendant will not return her money. But the defendant says the wishy-washy plaintiff can't just change her mind on a whim and expect a full refund. It's the case of give me back my money or else.
Thank you, Douglas.
You're welcome, ma'am.
All right, Ms. Tupou, what happened here?
I had asked for to rent a room, 2 bedrooms, and
how do you two know each other?
We're neighbors.
Okay, and you knew that he would rent out rooms. Wasn't somebody already living there, Mr. Mowat?
Yes.
So what did you do? Did she want to move in herself or rent them for someone else?
I understand that she runs a business taking care of elderly folks. And so she approached me on the rooms, and the rooms were already occupied by 2 of the tenants. And so we spoke more about it, how we was going to go about it, when she was going to come up with the deposit, when we were going to give them the 30-day notice.
But who was moving in? Was she moving in, or were her clients moving in? Who was moving in?
Her clients. Her clients were moving.
Okay, so you tell your tenants they have to leave.
Yes, once she gave me the deposit, I told her that then I'll issue my tenants 30-day notice so that they can leave.
So you give them a deposit. When do you give them the deposit?
I gave him the deposit on the 13th of April.
And when were your clients supposed to move in there?
In 30 days.
And then what happened?
Unfortunately, it didn't work out where the client is not able to move in. That's when I approached him again to get my deposit back.
And on what grounds did you want to get the deposit back?
I want my full amount.
No, I know you want it. I'm saying, legally speaking, why do you feel that you're entitled to get it back?
Deposit means that to hold the 2 rooms that I saw. But unfortunately, he had put in work in the house. That's what he told me. He had put work in the house, and he spent that money with the deposit.
Right. Now, what ended up happening, based on her representations, oh yeah, they're moving in, and without a lease, you went ahead and you told these other people to leave, and then now she wants a $2,500 back, plus you're not getting rent for the 2 bedrooms, right?
That's right.
Huh. Well, let me ask you, Ms. Tupou, do you have proof that you paid the deposit?
Yes, I do.
Because who is that?
He's my business partner.
Okay.
And I asked him to make the deposit, and I gave him the money to pay for the deposit.
Right. Okay, did you ever meet Leeds, Mr. Mowat?
I did.
Well, how do we know that Mr. isn't going to sue him tomorrow and say, hey, I'm the one whose name is on the cashier's check. Why are you returning the money to her? Like, I'm not even sure you have standing to sue because you're not the person whose name is on the cashier's check. But let's put that to a side. The point of a deposit, like you say, is to hold the apartment. And that means I'm gonna show you I'm serious. I'm gonna give you money, okay? But the other point of a deposit is that he takes it not only in this case isn't even like the regular cases where he just takes it off the market and doesn't rent it to anybody else. It's infinitely worse. He supposedly tells the people who are living there and paying rent that they need to go because somebody else is going to come here. So now you change your mind because according, I think, to your complaint, you found a better deal. And then he ends up now having no tenants. And you think he's supposed to return the $2,500?
Welcome back to the People's Court. Is this a case of no deposit, no return? Let's find out.
The tenants never left. He had tenants there.
Did the tenants never leave? Is that true, what she said?
True.
Did the tenants?
No, that's not true. The tenants left.
The tenant never left. They were there. They were there even after we talked. They never left.
Until when? Are they there now? Prove it. He says no, you say yes, prove it.
There's a couple that lived in the house, and she asked me that she can be a witness. She's a Tongan person.
Okay, call her as a witness. Go ahead. Let's hear her. Is she there to testify?
I need to call her.
No. We're not going to do that because we're not going to do that. All right? Look, the point of a deposit is that you're entering into a verbal agreement that you're renting the place. And if you turn out to change your mind and find a better deal, that's fine. But that costs you. That doesn't cost him. So I do not find that he has to return the money, and I don't even find that you would be legally entitled to the money anyway because you're not the person who's named on the cashier check or who handed it to him. It's someone you're calling your business partner. That could expose him to getting sued twice. But either way, a deposit has a purpose, and the purpose is to hold it. And to hold it is, I don't care if you have a letter from him, you're still not entitled to the deposit. You changed your mind. I know from the text you changed your mind. So you change your mind. That costs you. It doesn't cost him. Verdict for the defendant.
Thank you, Your Honor.
Ms. Tupou, how do you feel about that, ma'am? It didn't work out.
I don't like it,
and
it's not right.
You understand the reason the judge made that decision, don't you? It's because of that check and whose name was on the check.
I understand that.
I'm sorry, but you're out of luck in this case. Mr. Mawat, you must feel better now, I would assume. Am I right?
You're absolutely right.
You know, I was going to ask you, did the people you had in there, were they planning on moving out? Or did you just down and kick them out, want to kick them out?
Well, they were on a 1 month, not a long-term lease, month-to-month rent. So they knew that at any moment they could have left.
So you had the right to let them out. So has anybody moved in now?
Yes, everything is back to normal as it was before.
Okay, well, very good. Well, congratulations. Let's see what the judges have to say about it. Here they are.
One thing that you pointed out that was interesting is when, and some people just, I don't think they appreciate this, when you give a security deposit or when you give a deposit towards an apartment, more appropriately, that apartment is going to be taken out of circulation. That landlord can't rent it, and there's an opportunity cost, a lost opportunity cost in that period of time when it's out of commission. So in this case, there is a loss potentially to a landlord by tying up the property for this period of time.
In this case, and it was worse because he had the people leave. Right. Think about it before you put a deposit down. It's not free unless you make it free. Like you have to get something in writing that says fully refundable deposit.
Right.
Michelle wants to know this. Hey, Harvey. When a babysitter watches children in their own home, is there a strict parental liability for anything the child damages, or is the caregiver responsible? That's a good one, because if you're in charge of the child, you're in charge of making sure there isn't damage, so you're out of luck. We'll see you next time.